Welcome to Oceanside Library's virtual program. I'd now love to introduce Laura Adler-Greene for our presentation tonight. Thank you so much, Laura, for having us.
Thank you for inviting me to present this evening. I have, in the past 10 to 15 years, I am an adjunct professor at Torah Law School. I teach special ed law. I also have a young adult son who is on the autism spectrum. And so I work and live the area of special ed law and what's needed to support the special ed population. I'm going to start out with my first slide that talks about knowledge is power. I feel that when parents do have the knowledge and the understanding of the law, that they do have the power to question what may or may not be told to them by the school districts, or at least to understand what's available to them for their child. There are different areas of the law. There's state and federal laws. Part 200 is the New York State education law, and Part 201 guides children that may be disciplined under the state law. There's the Individual Disabilities Education Act, IDEA, the Individual Disabilities Education Improvement Act, and then there's Section 504, which we will get into a little bit later in the presentation. So my first question is, it was primarily the efforts of what group that educational rights of children with disabilities were recognized and eventually mandated? The answer to that question is parents. Parents have been the full force in advocating for their children, for laws to be implemented, and to make sure that special education children are supported within their districts. As far as parent-student participation, parents should be able to advocate on behalf of their child. Parents have the right to participate in all education planning. Students are the focus of special education, and it's the obligation of the school district to make strong efforts to ensure parental and student participation. If a committee on special education meeting is scheduled and a parent is unable to make it because of their work schedule, then it is the responsibility of the district to try in their best effort to make sure that the parent can participate in the meeting. And that could be either in person, which isn't really happening these days, but it would be through Skype, Zoom, or any other way in which a parent can participate in that meeting. Parent and student participation is guaranteed through the referral process, evaluations, eligibility determination, IEP development, placement decisions, and disciplinary actions. A parent is to receive 5 days notice prior to their CSE meeting. A parent should know all the evaluations that are going to be discussed at the CSE, especially in this time when CSEs are via Zoom. The parent should request from the CSE chairperson that they email to the parent all the evaluations that are going to be discussed, and if the CSE has a draft IEP that they're going to be going over, that should also be emailed to the parent so the parent can fully participate. These documents should not be emailed to the parent the morning of the meeting or during the meeting itself. So a parent has a right to consent, and consent must be obtained before the beginning or changing of a student's identification as IDEA eligible. What I'm referring to is there are situations where maybe the school district feels that the child should be declassified, no longer classified as a special education student. If that's the case, there should be evaluations that the parent can review and look over to determine whether or not they're in agreement with the declassification, and a parent is supposed to consent as to whether or not their child will be declassified. So special education, how does the law define special education? It's a specially designed instruction. It could be in the classroom, home, hospital, other settings to meet the unique needs of an eligible student, and or you have related services necessary to access and make progress in the general curriculum. Those related services could be speech, physical therapy, occupational therapy, services that support a child in their education. When is a student eligible for special education? In order for a student to be eligible for special education, there's 3 qualifications that must be satisfied. The student has one or more of the 13 itemized disabilities. Some of those 13 itemized disabilities are autism, ADHD, ADD, and deaf blindness. Those are just to name a few that are listed. The disability has to adversely affect a student's educational performance. If a student is in a general ed program and the student is having issues with reading, a number of students on the autism spectrum may have issues with decoding, comprehension, fluency. If they're having those issues due to the autism and they're unable to keep up with their non-disabled peers, then they would satisfy prong 2. And then the student requires special education in order to make effective progress. The student cannot maintain and keep up with their non-disabled peers unless there's some form of intervention. Now, when we're talking about adversely affects, just to go to prong 2, it doesn't necessarily just have to be academic. If a student is having behavioral issues where the student is being suspended, either an in-school suspension or an out-of-school suspension on a regular basis, that means that that student is not in the classroom, is missing work, and because of their disability, they are being adversely affected in their educational performance. Who determines eligibility? Well, when you're talking about students aged 3 to 5, it's the Committee on Preschool Special Education. When you're speaking of students from age 6 to 21, it is the Committee on Special Education. And again, the parent is a key member to the CPSE and the CSE. The role of the CSE. The CSE is to review evaluations, develop an individualized education program, determine placement for the student, and recommend services in the least restrictive environment. When we're talking about the least restrictive environment, we're talking about a continuum of placement. And we'll talk about this a little bit further, but part of the continuum will be a general education placement, inclusion. It's debated whether or not inclusion is part of the continuum. Self-contained classrooms, which would range from a 15-1-1 down to a 6-1-1. Hospitalization, before hospitalization, it would be BOCES, then hospitalization, and then home instruction is the most restrictive. The purpose of the evaluations are to determine the eligibility, develop goals and objectives in the individualized education plan, determine related services, determine behavioral services, if any, and the student, this is very important, a student must be evaluated in all areas of suspected disability. If a parent is stating that my student is behind, my child is behind in reading, but the school district does not evaluate the student on whether or not they have any form of a reading disability, then the student has not been evaluated in all areas of suspected disability. Independent educational evaluations, also known as IEE. This is one type of an evaluation. What occurs in this setting would be the parent is not in agreement with an evaluation or a recommendation by the school district. The parent then needs to, in writing, let the district know that they're not in agreement with that evaluation and they're requesting an independent educational evaluation at public expense. If the school district agrees to this IEE, then the parent is entitled to the one evaluation per one issue. So if the parent has an issue with regard to a speech evaluation or recommendation, the parent is entitled to that IEE at public expense. If the school district for some reason denies the parent's request for the IEE, there is not an appeal process. The parent would have to file an expedited due process hearing complaint. And then the school district has the burden to state that their particular evaluation and recommendation are appropriate. The IEP, Individualized Education Program. This develops and formalizes FAPE, a free appropriate public education for classified students. It must be individualized. It must be tailored to that specific student. IEPs are firm, legally binding commitments of resources from the school district. All services must be described and delivered. What's very important to note is that the IEP must be in effect by the beginning of the school year. Each special education student should have an IEP the day that that school year is to begin. Failure to properly develop and implement an IEP may render a student's entire special education program invalid. Measurable annual goals. At the CSE, the committee determines what goals are necessary in order for a child to succeed in school, what goals are appropriate in order for that child to succeed. Annual goals are projections of students' progress, one for each school year. Includes the academic and functional goals. The goals must be measurable and be measured. The IEP must describe how the student's progress towards the annual goals will be measured. And typically, the parents receive the progress report with regard to the goals every quarter. If a parent does not receive that, the parent should contact the CSE chairperson or the special ed director. If a child is having a problem behavior, and the behavior negatively affects his or her learning or the learning of others, the IEP team, the CSE, should consider strategies including positive behavior interventions. Usually what should be done is an FBA, a functional behavioral assessment, a behavior intervention plan, which is known as a BIP, and if need be, a behaviorist should be brought in to consult and to conduct the FBA and the BIP. Free appropriate public education. This is the backbone of a special education student's career, educational career. It involves special education and related services. It's provided at public expense. It is free. It has to meet state educational agency standards, provide in conformity with the IEP, and must be provided in the least restrictive environment, and that's the continuum that we had discussed. And it applies to special education and related services. What's considered an appropriate education? Well, there's many factors that will go into it. One of the important factors is child find. The school district has a responsibility that if they think that there's a child that is having difficulties within their classroom and learning, and the interventions that the school district is providing for that child is not working and they're not seeing any progress, then that child is a candidate under child find to be presented to the CSE, to special ed, and to determine whether or not this child is eligible for special education services. Least restrictive environment. So again, to the maximum extent appropriate, children with disabilities are to be educated with their non-disabled peers. What makes a certain placement more restrictive than another would be whether or not the special education student is integrated with their non-disabled peers. So again, for example, a gen ed class is the least restrictive because a child that has an IEP that's in a gen ed class is intermingling with his or her non-disabled peers within that classroom and probably with throughout their specialties and lunch and recess, depending on the age of the student. As you move down the continuum, if you have a child in a self-contained classroom, say a 15-1-1, 15 children, 1 teacher, 1 aide, you will not have non-disabled peers within that classroom. So the student will have less of an opportunity to be mingling with their non-disabled peers, making the 15-1-1 a more restrictive environment than the gen ed. Also, just to further note, a school that is designated for a particular population, a private school that's designated for a particular population, is also deemed more restrictive than a gen ed and even a self-contained classroom within a school district. Because in that private school, there's no opportunity for a special education student to intermingle with non-disabled peers. So we have LRE and FAPE. To determine FAPE, again, we have to look at the goals and objectives. To determine placement, can FAPE be achieved through general ed with support? If not, you have to move through the continuum that we have discussed. And the point of everything is to provide integrated experiences for special education students to a degree that is appropriate for that particular student. Again, LRE themes, we're talking about appropriateness, we're talking about individualization, one size does not fit all, and options. The entire continuum of placements must be available. We must start though with the notion of integration. Inappropriate considerations would be placement only according to classification. We're only putting the children that are classified on the autism spectrum in this particular classroom, even though it is a spectrum for a reason, and there are children that might be more appropriately placed if they are with gen ed students or in an inclusion atmosphere. Placement. Placement where services are traditionally provided. Some school districts have actual buildings that are just for the special education population. If that is not appropriate for your particular child, then you need to have the CSC and you need to discuss what placement is appropriate for your child. And usually evaluations can help support your position. So not all students with disabilities, not all students with disabilities have an IEP. Some have what is known as a 504 plan. 504 is not a special education law. It's a powerful non-discrimination law. And it is not part of the special education program. It's actually part of gen ed. But it is to enable children, students with disabilities to access classrooms the same as their non-disabled peers would be, and to provide them with the appropriate accommodations. The purpose of 504 is students with disabilities should be allowed to participate in the same academic and non-academic activities as their non-disabled peers. So just an example, a simple example to something like this. You have a high school student and he or she utilizes a wheelchair to get around the building. You have an old school building that does not have an elevator. The building is multiple floors. The chemistry lab is on the second floor. There aren't any labs on the first floor, and that student is not able to access chemistry as their class because they are not able to get to that class due to the building itself. That is discriminatory based on the student's disability. And the student then is being denied access to chemistry classes that their non-disabled peers are able to access because obviously they could utilize the steps to get to the chemistry lab on the second floor. Violations under 504 would be establishing classes for students with disabilities in areas that are not conducive to learning. And I just gave a few examples here. Also, a violation of a 504, a parent could bring a claim for a violation of 504 to the Office of Civil Rights, and then they would investigate whether or not discrimination actually did occur against the student within the school environment. If a parent is intending to litigate against a school district, they should first review the procedural safeguards notice. This notice provides parents with an understanding of what their individual rights are and also the rights and obligations of the school district. Now, if the parent is going to enter into any form of litigation, or if they're not in agreement with what the school district is offering, there are different dispute resolutions. These all take place outside of the courts. So we're talking about mediation, arbitration, and a state ed complaint. When we're talking about mediation, it's a collaborative problem-solving process. There's a trained impartial mediator who facilitates negotiations between the school district and the parents. The mediator has no authority to impose solutions, and the mediator cannot make a final decision. It has to be voluntary on both parties. If the parent would like to go to mediation, but the school district is not interested in going to mediation, or vice versa, then mediation will not occur. It is free. It occurs prior to bringing a formal due process complaint. Parents do not have to enter into mediation to resolve their disputes prior to filing a due process complaint. It's just another form to try and work things out with the school district. If a parent does enter into mediation and it does not work out, whatever was stated at the mediation cannot be used against them at a due process hearing, and it cannot be used to deny or delay a parent's right to a hearing. Issues that can lead to mediation. District's failure to identify, a district's failure to provide related services, failure to place the student in the least restrictive environment, and a violation of procedural issues as well. It could be notice, providing the parents with any kind of notice. As I said, it's required 5 days notice before a CSE. That would be a procedural issue. Arbitration. So when we're talking about arbitration, again, this is voluntary. Both parties must agree. The decision by the arbitrator is legally binding. The arbitrator listens to both sides, and you can appeal, but it must be stated so in the arbitration agreement prior to commencement of the arbitration. Stated complaint. This might be the one that parents are the most familiar with. When we're dealing with a stated complaint, there's been a violation of New York and federal law with regulations relating to the education of a student with a disability. A parent could submit a stated complaint. An attorney on behalf of a parent could submit a stated complaint as well. I actually just filed a stated complaint on behalf of parents seeking compensatory services. The school district did not properly implement the IEP this past summer when the student was entitled to extended school year services. So the stated complaint, the cause of action was failure to implement the IEP, and we're requesting for compensatory services to support the student, since that student did not receive the appropriate education during this summer. Findings of state complaint may not be appealed, but the parent could still submit a due process complaint if they're not in agreement. And then just if your parent does file a stated complaint, New York Education Department, they have 60 days from the time of filing to render a decision. So due process. Why is it filed? Some reasons parent file a due process complaint if they want the child to stay in their current placement or wish to parentally place the student. District is denying the student a free, appropriate public education. The parent is unhappy with the provision or refusal of services, and the district is refusing to classify a student. Both the parent and the school district can file due process complaints. Pendency is known as a stay put provision. If a child is in a particular placement and the parent is not happy with that placement, for example, if a child is in a 1511 and the parent feels that the child should be in a less restrictive placement, then and the school district is not in agreement, what will happen is that when the parent submits their due process complaint, the child is going to remain in the last agreed upon placement until the due process complaint hearing has been resolved. A due process hearing. Again, a parent or a school may initiate a hearing. Hearings may involve issues regarding identification. In New York, it is the school district that has the burden of proof. The hearing officer must be impartial. There's a 2-year statute of limitations, and that clock begins when the parent knew or should have known of the violation. Some remedies for a parent filing a due process complaint. If the parent is successful, could be tuition reimbursement. If the parent has unilaterally placed their child in an out-of-district placement and they're seeking reimbursement from the school district. If a parent's looking for additional services, compensatory services, like the remedy we had asked for in our state ed complaint. And then there could also be court action. With regard to tuition reimbursement, what a parent has to keep in mind is that if a parent is thinking about unilaterally placing their child in an out-of-district placement, they need to provide the school district with what is called a 10-day letter. In that 10-day letter, they're notifying the school district that they are going to unilaterally place their student, the reasons why they're doing so, and that they'll be seeking reimbursement. If a parent does not do that prior to unilaterally placing their child, the parent is going to have a problem when they seek reimbursement against the school district. So we have additional services. Additional services and compensatory services are used interchangeably these days, but basically what they both are is the student has not received what is in that student's IEP. The district has not provided it for the student, and so the student is entitled to additional/compensatory services. An example would be if the student's supposed to be receiving speech services 3 days a week for 40 minutes per session, and the speech therapist has not been able to provide those services. The speech therapist could have been pulled to attend CSE meetings via Zoom. The speech therapist could have been out sick and a replacement was not put in. These are areas in which the student didn't receive the services stated in their IEP and are entitled to those services. What we're talking about when we're talking about compensatory or additional services is that we're looking to remedy the progress lost by students with disabilities because they were previously denied an appropriate education. So now we have COVID and compensatory services, and this is an issue that parents are dealing with on a regular basis. We all know in March, schools shut down due to COVID. That in March 2020, the State Education Department released a memorandum, and in that memorandum, they had advised school districts and school personnel how to be moving forward. They said that students with special education should still be receiving a FAPE, a free appropriate public education. But there was a caveat to that. And the caveat was that they should receive a free appropriate education, but that the IEP should be presented, those services in the IEP should be presented to students at the greatest extent possible. And no one defined what is that, what does greatest extent possible mean? Then in June of 2020, the State Ed Department put out a memorandum with regard to explaining Governor Cuomo's June 5th memorandum that said that we could have summer school. Summer school can exist. If school districts are not able to do it in person, that the school districts can provide summer school. This is the ESY services to students remotely. But again, the IEP is to be implemented to the greatest extent possible. Now, greatest extent possible, again, there isn't any definition as to what that should be. So now there are questions and a little more confusion. And also one of the reasons why state ed complaints like the one I filed this summer, I am assuming that other state ed complaints and possibly even due process complaints were filed following the summer because greatest extent possible has not been defined, and a number of students, their IEPs were not implemented to the greatest extent possible. Another question is each district implementing the IEPs the same? Does greatest extent possible mean the same under each district? Did special education students receive a FAPE under these new guidelines from March to June? And did students who receive extended school year services because they substantially regress with regard to the academic services that are provided to them during the school year, did they truly receive a free appropriate public education this summer? And then is there any precedent for any of this? And the answer to that obviously is there isn't. So the summary of school district responsibilities, they should involve parents as full participants in the IEP process, even with the Zoom meetings. They should develop meaningful education IEPs and 504 plans. They should implement the IEP to the greatest extent possible with no excuses. and they should be consistent in providing a FAPE to our students. I thank you for listening to this presentation, and I'd be happy to answer any questions that you may have. If you want to contact me directly, I have my email at lag@amcohenlaw.com, and you could also reach me, call me at 516-877-0595. Thank you.
Thank you so much, Laura. Let me end the recording here.